will start promptly at 10 o'clock, but feel free to listen in as Jake and I chit chat. So a lot of good questions this month, Jake.
Yeah, some pretty good ones. Thought actually fantastic questions. Really
so we could use the same questions as last month and just change the answers.
Yeah, that'd be a good idea.
Yeah. It's who's Celtics there? Is that
Jason
Tatum?
Mm-hmm.
So I think some player from opposing team tried to fist pump his son. I guess little child, and the kid refused to.
Oh, that's good.
Yeah, it was funny. Wow. So
who was the player? LeBron James?
No, it wasn't LeBron James, but it was somebody from Cleveland.
Oh, was it Cleveland?
I thought it was Cleveland. Yeah.
Was it Donovan Mitchell?
Might have been. It's somebody that Tatum Brown is friendly with, it appeared.
He's pretty popular amongst the players. He's really grown into his own.
Tatum, yeah, I like him. Did you hear about Willie McGinnis?
Oh, he's in big trouble.
What did he do? It was in Los Angeles or in California.
He assaulted someone.
He allegedly assaulted.
Yeah, no, it was on tape.
No. There's the public is listening, so he allegedly assaulted someone other than a significant other.
Well, it was in public. They have it on videotape.
But was it a third person, not a spouse or a significant other?
No, it wasn't domestic violence.
Oh, good. Okay.
A public event. And
what did you put somebody? Dina?
Hi, Dina.
Hi, Dina. Seems odd that we only have 5 attendees.
Yeah, what's going on?
Unless Dina tells us otherwise, I think, yeah. I think we start in 1 minute.
Yeah, I think so too. All right, well, I guess yeah, we should start soon.
Again, I'm sending
okay. All right, people are coming in. I think it's just
okay. Want to get going?
Yeah, let's do it.
Okay. I had a question before we start. Does Zoom make me look fat?
No, your fat makes you look fat.
Oh, thank you. So speaking of Ozempic and pickleball, the 2 hot topics. The Boston Globe today did an article about Wellesley residents complaining about too much noise from the pop of pickleball. When the pandemic started, March 2020, I was working with attorneys across the country on different COVID rules, and people started sending me sample rules for pickleball, and I had no idea what it was. But the firm is doing an outing on March 31st at 1 to 4 at someplace in Boston, South Boston.
Yep. So that is, we're doing our pickleball social. It's from 1 to 4 p.m. in South Boston. Should be a big turnout. So that's a good lead-in for pickleball being the fastest growing sport in the world, especially to have 40 million players by 2030. So
And my cardiologist this morning told me that Ozempic is the only time in his history where people are demanding a specific drug such as Ozempic. He says, yeah, in the past people might ask for an antibiotic. Now they're specifically saying, I want Ozempic. They expect $10 billion of sales, more than any pharmaceutical company in the world this year. And it's getting very difficult to get for people with diabetes. It also helps with heart issues, but also with weight loss. But it's become wildly popular, and there are short supplies. So I suspect what we'll see is some kind of black market where people on the sidewalks of Dover will be selling it. Anyway, Jake, you want to take it from here?
yeah, no, absolutely. And that is correct. I'm about to type in the address of the event. It'll be 1 to 4 p.m. In South Boston. And it should be a good turnout. We're hoping to not only is pickleball is important and growing across the world, but it's also quite the it's always been evident in communities, and it's kind of a mix in between tennis and ping pong. I don't actually know all the rules. Do you, Stephen?
No, but we'll learn them by March 31st. For the people attending, thank you. We got a lot of questions that people submitted upon registering, so we will attempt to answer all those today, but feel free to add questions in either the chat or the Q&A, and Jake will have that printed out. And like last month, next week, we'll send a response to all who signed up, giving the answers to those questions as well. Jake, do you have the first question?
Yep. So yeah, and feel free to type in questions as we go. We'll certainly follow up either during this session if we get to it, or afterward. But I will actually do a share screen because we are doing a PowerPoint as well. The use of visual aids should be helpful for this this presentation. So
Twins.
Which one's you?
I'm on the right.
You're the clock on the bottom. So actually, yeah, we actually had a short month because we had our last session on February 10th, and now we are into March Madness. So we are doing the first week of March. You may notice a Celtics jersey behind me. That is the great Jason Tatum going for an MVP run. For those who joined today, you actually have a chance to, or if you submitted questions before, you have a chance to win Celtics tickets next Wednesday, March 8th. They play the Portland Trailblazers and Damian Lillard, who had 71 points the other night. So we're doing a giveaway before we get to our March Madness. we type Celtics, ask any question in the chat, and you are eligible to win Celtics tickets. Or if you asked a question before. But now we'll get to the actual fun stuff. All right, so first question. Eviction processes for commercial unit owner. Can an association require a unit owner to evict or refuse to renew the lease of a commercial tenant that is repeatedly violating association's rules and regulations that are harming the community? For example, cleanliness and standards. So for this question, we'd probably need a little more of the actual facts specific. Is it a restaurant? Is it a store? Sorry, I'm flipping the questions.
There you
back.
go.
Yep, we're on it. So we need to know a little bit more. Is it a restaurant? Is it from noise? Is it from smells? Is it simply cleanliness? If it is a cleanliness issue, you may want to consider contacting the local Board of Health. That could help with kind of remedying that situation. Generally, as far as evicting for certain violations, and this applies to commercial unit owners as well. A judge or a court is generally is going to give the unit owner some time to remedy the violation rather than immediate termination. Another recommendation is potentially review the lease terms. This may define what constitutes a breach under your agreement, and also have a timeline to cure the breaches. In the meantime, yeah, there's some steps you can take. Recommend consulting an attorney who can go over the exact time frame statutorily within your with your state. But generally, yeah, sending a warning or a notice of the lease violation, as well as which will pertain directly to the contract terms, is probably a good first step. If the unit owner then fails to cure the violations, that's when you can potentially initiate an eviction proceeding. But generally, yeah, there's going to be a review period, and you're also going to, yeah, if it's a cleanliness issue alone, you're going to want to contact the Board of Health. That could potentially eradicate or at least get an investigation going.
And I'll just add on to that if it's a Massachusetts condominium, which I know in this case it is, under Mass General Laws, Chapter 183A, if there's misconduct, the unit owner is responsible for the actions of its tenant, and is responsible for the legal fees and costs involved with any legal action or litigation. So not only would the unit owner have to be paying for its own attorneys, it would also be paying a share, it would also be assessed the legal fees incurred by the association. But as with all these questions, you really need to consult with your attorney who can take a deeper dive, but hopefully this gives decent guidelines. You ready for the second one, Jake?
Yep, let's get to it.
Secondhand smoke. Are there any laws that address secondhand smoke traveling from a neighbor's unit? We got a couple of questions on secondhand smoke. The first thing is that starting with the case out in Colorado, it was determined by a court out there that a amendment to their declaration, what we would call Massachusetts master deed, prohibiting smoking, would be effective against even existing owners retroactively. It was a 4-unit condominium, one smoked, the 3 others voted to amend, and the court upheld that. So in Massachusetts, an amendment to the master deed, trust of bylaws, we believe would be upheld. In terms of just questions between the 2 units, there are steps that could be taken, such as requiring door sweeps under the door of the unit that in which the smoker resides, and smokeless ashtrays, and perhaps asking people to smoke away from the HVAC system. I know of one case where somebody brought a nuisance claim against a neighbor and against the board. The board won on that case, but there may have been rights against the neighboring owner for a nuisance claim and the dangers from the secondhand smoke. So there was also a comment that there was an attempt to amend and it didn't get the votes, and the person submitting the question thinks it's because the investor owners didn't want restrictions such as that. What we found is that over the past 7 years, the research indicates that smokeless buildings are more desirable than smoking buildings. So that might be a question of just making the investor owners and the owners who live there aware of the marketability and the desirability of no smoke buildings. Jake?
All right. And yeah, actually, it's kind of a good segue to our next question, which refers to noise complaints. How should unit owners deal with excessive noise coming from a neighboring unit? Can I require another unit owner to soundproof their unit? Funny enough, Stephen and I had a lot of discourse on this question. It's not as simple as it sounds, even though you would think, oh, noise, that's a huge issue. Everyone deals with it. That should be pretty black and white. There is a lot of in between. And this question in particular referred to day-to-day noise. And in the question specifically referred to kids walking around, but not necessarily. There was some about screaming in the question. But not like, it wasn't like banging on walls or yelling or loud music during late hours, which would be pretty obvious noise complaints. This was about kids walking around, kids kind of playing throughout the day, some at night, so it bled into it a bit. So generally, as to just, noise complaints or a nuisance, the governing documents should address what a nuisance is and what would constitute unreasonable interference with another person's property. That being said, a big qualifier here, noise is relative. Courts have implemented a reasonable person standard to define a nuisance, which specifies, would a reasonable person be annoyed by this noise? Now, this specific question says, can I require the unit owner to soundproof their unit? If it's a situation where the walls are too thin, or you believe the walls are too thin, and it sounds like your neighbor is basically in your unit, but they're not doing anything unreasonable. They're not playing loud music. It's kids walking around. I mean, you're not going to be able to tell the kids to float or not walk on the floor, or get a restraining order to tell the kids that they can't walk during certain hours of the day. That would be obviously not practical. But yeah, if you do think it's a construction issue or an actual building issue, you're either going to want to, you could ask the board and the property manager about the issue, and kind of see if the walls, you think they were poorly installed. The biggest thing I would probably say about this, if you're a sole unit owner and you're going to the board and property manager, you're going to have a less likelihood of success on the merits than if you kind of, talk with other unit owners, see if they're experiencing the same issue, and see if they're like, oh yeah, every time I hear my neighbor come home, it's like banging, even though they're just walking on the floor. That could result in, the more people you pull together in your community, and go to the board and the property manager and say, hey, we're all experiencing this issue. That could get more.
I would just add to it that there are sound deadening requirements where there has to be a certain amount of sound deadening to the between units for sound transmission. The other thing,
Yeah,
and
I was gonna actually say, yeah, call an, if everyone agrees, call an engineer, someone who could look into a potential sound transmission issue.
and then I was the final thing is years and years ago, the community associations, the Institute, the New England chapter, the attorneys committee adopted a standard or guidelines on dealing with neighbor to neighbor disputes. And other than cases such as here, where there could be if you went after the children, there could be discrimination claims in Massachusetts. So that's dangerous. But there was a time when there were no condominiums, and they really didn't blow up here until like the 1980s. And what did people do when there were subdivisions or living in an apartment buildings? And I think what has happened, unfortunately, is neighbors have stopped talking to each other. So if you have a problem with your neighbor, well, gee, that's why we pay the manager. That's why that's what the trustees are trying to take care of. They have to deal with this problem. And the problem is sound, the amount of noise is subjective. And if it's subjective, you could, the manager could and board could listen to the noise and come up with a determination. And there could be measures such as if there were wooden floors or putting area rugs or something of that nature.
Yeah, and that's a great point, Steve. Bringing the community together, taking an issue and bringing the community together. Maybe ask your neighbor if they want to, play a game of pickleball. Use it as a point of camaraderie rather than a contention. Yeah, come to our social on March 31st. Tell them, hey, we can go play a game of pickleball and work it out. But no, all jokes aside, it's important to kind of try to come together. And yeah, if that's not practical or the unit owner is not approachable, talk to other neighbors and see if they're experiencing the same issue. It's a good idea to bring people together. And just to one last point on this, we actually received 2 questions on noise complaints. We received another complaint, and I think this person, it's from a property manager, so it's from the other perspective of a unit owner who's complaining about another unit owner who has a dog who's allegedly barking for 12 hours a day. The unit owners are not agreeing to work it out, it sounds like, or if they're not agreeing to work it out, potentially the property manager and board can look into the issue and see if the barking is incessant. But you're going to need, the unit owners will need some evidence or some proof or coming together before just enforcing on he said, she said, oh, the dog's barking 12 hours. Well, he's going to say, no, it's not. Bring the property manager in, see if the issue is actually going on. This property manager actually very insightful, said potentially bring the 2 unit owners together to talk it out. And that's honestly, that's a pretty good first step to try and bridge the gap on these issues.
Yeah, hopefully it'll be the last step. The idea is that neighbors should be able to resolve most disputes between themselves, but the board, but we know that doesn't happen in some cases. The board or the manager could certainly act to mediate those disputes. Jake, next question, because we're
that was surprisingly a long one. And yeah, people are curious about this issue. It's definitely a big one. So on you.
Okay, on annual meetings, the question is, can there be no annual meetings? I've never heard that question before. If it's a corporation, there might be, if it's incorporated, but most aren't in Massachusetts, there might be a requirement for annual meetings. I suppose one could amend the documents to amend out the annual meeting, but in order to provide transparency, et cetera, I guess my suggestion, and certainly became very popular during COVID, is Zoom meetings where the question was, our last 2 annual meetings have been a disaster and inefficient. With Zoom meetings, it can be controlled. You could bring in a parliamentarian, in some cases, lawyers. We've been asked to go in as head up run the meeting, so that only one person raises their hand and talks and with Zoom you can mute and unmute people, but I would aim more for using some of these tactics to make the meetings less of a disaster and more efficient. And I think it's possible. I think meetings of unit owners are good to carry on transparency. Jake, next question.
Yeah, and to that point, electronic and virtual meetings, actually in Florida, which Florida seems to be a trendsetter in a lot of issues right now. In the statute, it actually allows for virtual and electronic meetings and voting. There's a ton of software that's coming out, apps that are being used. We've used it, or at least I've been in contact with a few vendors, one called Get Quorum, another called ONR. They're both nationwide, and they do, so they can do work in New England, Florida, wherever. Both of those vendors or apps that they have kind of just has seamless meeting and voting software. So it'd be even more, for voting, it makes sure there's no fraudulent voting, nothing going on there. But yeah, it's a very developing topic. So brings us to our next one, which is election protocol. Can you have an election for board members without a quorum? Can board members make financial decisions based on email consent? This is a multi-part question. Can boards record meetings and delete recordings after 30 days? So just for the specifics of this question, and as a disclaimer, this was a New Hampshire question. I'm not licensed to practice in New Hampshire. My partner, Ed Alcock, was the resource for this question. So I am conveying, that's the disclaimer here. New Hampshire law, not the same as Massachusetts necessarily, although there's close statutes provisions. But basically to the question, you're going to want to confirm with your state statute, but for New Hampshire, the answers to all these questions, generally speaking, is no. Generally, you need a quorum at the beginning of the meeting to proceed with actions at an annual or special meeting. In New Hampshire, the statutory quorum is 33.3%, but documents can provide for as low as 25% to meet quorum. That being said, proxies can count towards a quorum, and you may be able to elect directors without a meeting, but you would still need a quorum. Again, back to the electronic or virtual meetings, potentially doing so by email. Opens up, but the more specific details you'd want to consult with an attorney. But yeah, it would certainly be possible to do so without a meeting. To that point in 2016, the New Hampshire amendments opened up the process and eliminated closed meetings, but all actions must be taken during a meeting of the board, which can be held by electronic means. And that goes back to it's a changing landscape, electronic meetings, virtual voting, electronic voting, all fair game coming into play. Not going to be able to avoid it, and actually makes things more practical. In Florida, you have to opt in. You have to opt in to the electronic voting mechanism. So that's something to keep in mind. So you can still, if you don't like the virtual electronic, you don't trust it. Don't trust technology. Technology that's been a big topic. Steve and I have been talking about ChatGPT, all that. It's not going away. It's something that's going to keep developing, and we're going to have to keep up with. But if you don't like it, at least in Florida, you have to opt into electronic voting. So that's something to keep in mind. I'm sure states will follow Florida, and we'll see more and more electronic means of doing things in communities. So next question.
And somebody made a good comment, which is for meeting control of using Robert's Rules of Orders, the rules of order. There are various versions, and there's additions for smaller groups. A lot of people don't, in Massachusetts anyway, don't really know Robert's Rules of Orders, but certainly some kind of order system could help. The next question is interesting and horrific. It's on pyrrhotite. So, and it's what are our options to address crumbling foundations? Can insurance be held responsible? Help. In this case, what is pyrrhotite? In a quarry in Connecticut, there were excessive amounts of sulfide, I believe, which caused the minerals to be used in concrete foundations within a 44 miles from this place in quarry in Connecticut. The foundations were used in 1983. They were outlawed. The problem is that over time, and in this case, the person has been in the unit for 28 years, is that pyrrhotite is a massive problem, and it starts crumbling and cracking. And the fix is to lift up the homes and replace the foundation. For single family homes, it's estimated to be about $200,000 per unit. So what did people do? In Connecticut, there's legislation that helps with grants and all that. In Massachusetts, I found out that there was a Facebook group called Homeowners Against Crumbling Concrete, and there is legislation filed for this legislative session in Massachusetts. Perhaps join that group, perhaps get CAI involved, because I don't know if the proposed legislation is addressing condominiums as well, but it should be. And it seems like a legislative process to fix the issue, because it's just devastating, and people are going to lose their homes if they have to pay $200,000 for a fix. The question on insurance would have to delve into that more, or you should have your association attorney do that. The question said that 28 years ago, foundations were covered, but now they're not. My understanding typically, and you could be an exception, is that deterioration over time is not a sudden and accidental loss, and therefore is not an insured loss. So even though your foundations might be protected against other casualties, deterioration over time typically isn't one of them. Though there is an insurance regulation in Massachusetts that says you cannot deny coverage to properties that have pyrrhotite, but it then goes on and says, but this does not mean that it's a covered loss. So a great question. Talk to your attorney more at length on it, or give us a call and we can chat more about what your specific circumstances can be. But we hope that you're successful, because it's a horrible problem to have.
Absolutely. So we also received a note, and this probably relates to the disaster annual meetings, implement strict use of Robert's Rules of Order and hire a police detail. No, that's actually a really good point. And more, especially at meetings that become a disaster, or this potential disorderly conduct. I mean, we've seen some interesting things at some of these meetings where it can get pretty intense. So
no joke, but one of my condominium lawyer friends from Atlanta had a case where the property manager, and this was within the past year, was assassinated by a unit owner, they had to put police details for two of the attorneys at the firm. And I understand that condominiums just follow the rest of the world, but the world is angry. The divisions are horrible, and it doesn't end at the condominium level. So police details, as crazy as it might have sounded at some point, is not a bad idea. The Zoom meetings might be another idea, but I don't have an answer as to how do you stop a unit owner from going into the office and assaulting the property manager or the on-site manager or one of the trustees.
Yeah, unfortunately, and this was a question last week, do you think the kind of attitudes of unit owners and boards have gotten better or worse over the last 30 years? Unfortunately, and I think because of the pandemic and people being cooped up and division and politics, unfortunately, people are getting, and mental health, that's also been an issue. We'll actually get to a question on that in a minute. Unfortunately, it's becoming worse, and we don't mean to scare you, but yeah, these are things that you have to look out for. Definitely, yeah, police detail, enforcing more security, that's becoming very real. So let's get to the next question, hopefully. And just to change the mood a little bit, again, Celtics tickets we're giving away next Wednesday. Type in Celtics, any question in the chat, and you'll be eligible to win 2 tickets. And also, yeah, big game against the Trailblazers. So let's get to the next question.
And a Ginzu knife if you act within the next 2 hours. Jake won't understand that. Either will half the audience, other than my good friend out in California who is listening in. So the next question is on fines. Jake, that's mine, right?
Yeah. No, I got
Okay.
this one.
Okay, you got it. Okay.
Next up, man. All right, fines, and this goes back to, I mean, enforcing issues in the community. Fines and associations. What is a recommended fine structure, and is there an alternative to fines? This one is super case by case specific, and very contingent on the type of association you are dealing with, and even the fine you're dealing with. What's the violation? Every violation should be dealt with on a case by case basis. First and foremost, generally a fine may not be imposed unless there is written notice for whatever violation is occurring. This is likely contingent on the governing documents, rules and regulations. And you know, if after the written notice, potentially I believe it's some type of hearing, or at least allowing the opportunity for a hearing for the unit owner. If the unit owner still remains non-compliant, fines generally serve as an effective way to kind of discourage the continuing actions or violations. And you know, if they continue, then you have it's documented, written notices there. They continue violating. Second notice, third notice. All right, then you can, as we discussed earlier, you can start the eviction proceedings if you so choose. But this question specifically asks the second part of the question, alternative to fines. It's appropriate in some instances. For example, associations may, and this is a Florida law. It has a provision in Chapter 718. Associations may suspend unit owners' rights to common elements or facilities for a reasonable amount of time for failure to comply with the governing documents. So what this would mean, you know, if someone has a noise disturbance in a pool area, back to the noise complaints, it could be a good idea to implement suspension from going to that area. If they're seen there, that's a violation, and that's when, I would say fines is probably the next step that you would take, or written notice and then fines. And you'd want to talk to an attorney as to the merits of the violations, as well as just as far as what the next steps are according to your governing documents and your state statute, as to the next steps in implementing and either finding them or finding an alternative for fines. Again, pool area, common areas, maybe parking privileges.
In New Hampshire, the statute allows termination of use of common areas as enforcement measures. So in New Hampshire, and it's been upheld by the courts, as I understand up to this point, even to the extent that an association put those cement barricades in front of somebody's driveway. So New Hampshire is different than Massachusetts, but the fines, the question is for what purpose? If you fine $25 a day and the fines are $30,000 and you take no enforcement measures in court, judges are not inclined to grant you that. Plus, it doesn't get rid of the issue that you're fining for. So at some point, you have to use enforcement. For those in New Hampshire, and I think this question is from New Hampshire, use the ability to take away rights to use of common area as a method, and talk to your association counsel about that. Are we ready to move on, Jake? Or?
Let's do it.
Okay, and so somebody asked about somebody complaining about a roof and noise from a HVAC system. There's a similar case in Massachusetts about that, just on Hill Realty. I think it related to the Burke House. We'd have to take a deeper dive or talk to your attorneys about that. But like most answers of attorneys, it depends. So this is mine, Jake?
Yeah, also just to that point, keep submitting questions in the chat. If we don't get to it in this session, we will be submitting answers and all that after in a document. And if you submit a question, you have a chance to win Celtics tickets for next Wednesday. So,
Jake, and you know how to print out these chats and Q&As from your machine?
Yeah, I'm probably not going to print it out, but I'll know how to get it to our devices and then get it to the email, and then we'll digest it, and then we'll send out responses.
Could you mail me a stamped copy?
Yeah,
we truly will answer every question on there as best we can. A few people found it helpful the last time. On budgets and association pushback, in Massachusetts, most associations do not require a vote of unit owners to approve a budget. That's not common. In a lot of states, a vote is required, or sometimes it's a negative vote, so that you could vote to, unit owners could vote to reverse a budget. But in Massachusetts, I think it's set up the way it's supposed to be. People elect trustees. That's the most power unit owners have in picking the right trustees, and then having them make the decisions with transparency and communications about what is needed. If there, and then there's a question about what if a loan is needed, and I guess my suggestion there is, even though you don't need a vote on the budget, and you probably don't need a vote, at least in Massachusetts, but it depends on the documents, to borrow, is a good idea to have a communication, Zoom meeting, whatever, where you present what's being done. For example, if there are millions of dollars of engineering issues that have to be addressed to avoid a disastrous result as occurred in Surfside, Florida, then you gather with the owners, have the engineers there to answer questions, and then the bank representative, because actually there are some lenders, I know of Video and Social Bank, that do 25 to 30 year loans, and it might be better to pay a $300,000 assessment per unit, for example, over 30 years than at once. I'm going to forget some of the banks, but there's Brookline Bank, Rockland Trust, and other banks that you can talk to us or talk to your attorneys about or manager about who do these type of loans. But the loan is actually makes it much more affordable because it spreads it out over a long period of time. Jake?
Cool.
Next question.
Yep, next question. All right, so this one's on sump pumps. A unit owner is experiencing seeping through the concrete floor. Area is considered unit, then that, I should say, the concrete floor area is considered the unit owner's responsibility. The unit owner wants the association to install a sump pump. The sump pump is located in the common areas. Other owners in the past of this community have been responsible for the sump pump payments and maintenance. And the governing documents are silent as to sump pump. Who is responsible? So for this one, my recommendation here is even if the governing documents appear silent as to sump pump specifically, we'd recommend consulting an attorney to conduct careful review of the governing documents and possibly the state statute to interpret the language. And what I mean by that is you can look at some state statutes, for example, for common elements are defined as any portion of the association that serves more than one unit. So even if sump pump, and look, I mean, it's similar to the United States Constitution or really any legal documents, it's subject to interpretation, and over time that develops. The classic example that we hear every day is the right to bear arms. Well, guns in, or the Second Amendment, guns in when the Constitution was written was different than what guns are today. So it's up to interpretation, and even if the governing documents appear silent as to the actual word sump pump, it's something that you're going to want to look into.
Jake, I think if I could add.
I thought you had a thought on this because we did discuss this before.
Yeah. So in my mind, the question was a great question. The manager knew exactly what she was asking. The unit owner is responsible for the upper surface of the concrete foundation, meaning the rest of it is common area. The infiltration of water into units in Massachusetts is highly likely to be a violation of the state sanitary code and the state building code. The repairs typically would either be to the foundations themselves, requiring digging out and putting on that black stuff that stops leakage. If some pumps are a way and more affordable that work, I would suggest that the association is responsible for that expense. You can have the unit owner responsible for the electricity, but the association should pay for the sump pump installation. I think this is different than radon, which the questionnaire also asked about. Radon is from disintegrating granite over hundreds of years, and it comes through the floors and goes into the homes and makes the levels potentially dangerous. In those cases, we don't think that it's a responsibility of the association. It doesn't violate state sanitary code or state building code. They're only guidance on radon. So we think that there's a distinction, but we're happy to talk to you about the two. I know we're getting short on time, Jake, so I don't know if you want to rush on.
Yep, let's go on 1.5 speed now.
Okay.
This is an important question.
Okay, on mental health. What steps should property managers take to deal with residents who are experiencing dementia or mental health? And then what about residents who harbor known criminals that affect community? On the mental health one, the word is compassion. That mental health is a sickness that is not intentional behavior. And the first step, whether it's elderly who might have dementia or whatever age, is to contact the family, and you can see if you can get the family involved. And then the next step is to call, if it's seniors, elder services, if not social service agencies in your town at the state level, to see what they can do. And then only all that has failed, if there's a housing court available, it would be perfect, but Superior Court would be okay as well. But with the housing court, you sit down with somebody who tries to mediate the issues first. And in our experience, we've had the ability of the mediator understanding that somebody, for example, was boiling water consistently and forgot that they were boiling water and was setting off the smoke alarms in a gas-fired luxury high-rise in Boston. And the judge, with compassion, looked at the owners and said, I'm not gonna make you move, but I'm gonna require that you have somebody who, I'm gonna require a lock on the stove and oven. I'm gonna require that they come in, that a caretaker come in with the key to the oven, that they prepare your meals. And because I'm afraid that you're gonna kill yourselves or the 200 other residents in the building. So be compassionate is the key word. Residents who harbor known criminals that affect community. Well, I don't know if the post office still posts the 10 most wanted criminals, but if there's a weapon involved, if it's drug trafficking, during the COVID, I watched too many episodes of Breaking Bad, but I would start with the police department to see what exactly is the situation. It's sometimes difficult to get CORI records, criminal offense records, but gather up all the information as to what the dangers are, and then speak to your attorney and take a course of action from there. Jake?
All right. Yep.
We have 12 minutes.
All right. Okay, so next one, it actually kind of relates, goes back to safety and health. Absentee owner and keys. Our association has no master keys, but a unit owner is leaving his unit vacant. For the safety of our building, we have requested the owner leave keys with a trustee. Owner refused. What can trustees do? Similar, so generally every unit owner is entitled to exclusive ownership and possession of their unit, subject to the governing documents. That being said, Massachusetts General Law 183A, Section 4, which this is the law that applies for this question. Again, check your specific state statute or consult with an attorney to interpret the state statute. Specifies that, and I looked through a couple statutes. Florida's basically similar language. But this statute specifies that unit ownership is subject to the right of the organization of unit owners to have reasonable access to the units during reasonable hours for the maintenance, repair, or replacement of the common areas, and for making emergency repairs to prevent damage to the common areas or other units. So yeah, you have a right to get into this person's unit. If the unit owner is refusing, practically speaking, I mean, yeah, how are you going to get in if you don't have master keys? You may need to send a demand letter to recoup the keys, and you can cite this exact statutory provision, and eventually that should compel access to the unit.
So first of all, I'm smiling at Grasshopper as he starts citing chapter and verse from Mass General Laws, chapter 183A, section 4.
I didn't even know it was 183A last week. I thought it was 183 regular.
We added the A just to confuse you. So the other thing you can do, based on experience, is if they refuse to give the key, either bring in a locksmith or break the door down. If there's a fire in that unit, or if the water heater goes and it's going to damage 20 floors below all the units, break the door down, bring in a locksmith, but we'll do whatever you have to with axes and whatever else that the fire department comes in with. And yeah, the unit owner can pay you now or pay you later. They can give you a key, and that gives you some responsibilities in terms of securing those keys, which is another total issue on premises liability. There may be reasons why you don't want to have keys, but if you break down the door, it's going to be much more expensive for the unit owner than if they had complied. I assume a lot of people now have the machines you put on the door that you press like a code, and or like hotels have, where you flash the card over the door. But anyway, maybe lockbox. One of our participants, April, is giving us all is feeding us some great answers on the lockbox. Here's one other thing. This one I learned back in 1979. Don't have a lockbox where they you could have a lockbox that the realtors use, and that could work. If you keep the keys somewhere else and they're actual keys, do not code them with the unit number, because that would present a whole lot of liability. But the lockbox idea would work. And just be sure to take careful steps to not inherit any liability.
All right.
Next question.
Yeah, we have about 7 minutes, so it's
okay. We'll just talk quickly. We keep saying that. Does any Massachusetts state law exist that protects unit owners? This question was asked last month as well. Yes, there's thousands of laws that protect the residents of the Commonwealth of Massachusetts, and the Condominium Act has requirements for what boards should do. I think that the concern that the unit owner is presenting with this question is that in order to enforce your rights under the Condominium Act, you might have to take legal action, and that comes with a cost. But there's a world of difference between saying that there's no protections for unit owners when there are plenty. The difference is you have to take action, small claims court or a superior court, a district court, but you have to take action if you want to enforce these. And if you have a group of owners who want to do it, they can come together and bring an action. But plenty of consumer protection in Massachusetts, but you have to pull the trigger and take the action, whether it's arbitration under your documents or a court action.
Yep. And we have the condo acts on our website. Florida actually has a DBPR, which is Department of Business, Department of Business and Professional Regulation, and there's a division of condominiums. And there's plenty of actions that are usually that's the facilitator into, or a easier way than legal action. But let's get to the next question. This relates to Rhode Island law. Disclaimer, I'm not licensed in Rhode Island. This one has a law that requires a new association to be set up if a development is not completed within 10 years. Is the original association responsible for all maintenance and replacement of roads without any support from the second association? And again, I spoke with an attorney in our office, Ed Alcock, actually the managing partner of our firm. He's not aware of any 10-year law, but this may be a limitation on development rights contained in your governing documents. It sounds like your association, like many Rhode Island condominiums, has a master and a sub-condominium structure. My partner, Ed Alcock, he's happy to answer this question. We talked to him about it. Again, we will have responses in writing to these, and this is one we'll include because I know this is kind of a punting on the answer. But yeah, it's probably a master sub component issue, and we will get to this one through our attorney, Ed Alcock. So
and you can and we're not telling you not to call your own attorney if the association has an attorney. And there's an argument that the last 26 units that aren't part of the association are being unjustly enriched. They're getting a value from the roads, and there are cases where this is being disputed. But just on fairness alone, is it fair that the 26 people in the second community get a free ride? Next question. Rules and regulations do not have to be recorded to be enforceable. When I started practicing, so passed the bar in 1979, somewhere in the 80s, I think I came up with the idea, but it could have been anybody, who knows. I could also say my parents were on the Mayflower. But we started all agreeing, the condominium attorneys, which is a pretty sharing group and a lot of collegiality. And the consensus was, well, if you record the rules and regulations, then it's notice to the world as to what they say. So somebody buying or renting, take subject to them. If you pass rules and regulations, your documents don't require recording, record anyway. And the other thing it will do is, one, it's this constructive notice because it's public record, and two, it's you could place it on the your portal with the rest of the condominium documents and give it as a package to owners, whether there's a fee for that or not. I see a lot of questions are coming in on I guess my use of machine for anything invented after 1970. I was just informed that it's really called the fob. But thank you. We have Jake for all these fancy new words. Next one, Jake.
Chat GPT will tell us also. And I know we're getting close to the hour, but type Celtics or any questions in the chat. Celtics or any questions. You have a chance to win, not the jersey, but you have a chance to win 2 Celtics tickets for next Wednesday against the Portland Trailblazers. So type in Celtics, type in a question, and you're eligible. Next question: fiduciary duties in the absence of an association's board. Do unit owners have any fiduciary duties? Unit owners do not have fiduciary responsibilities. The board has the fiduciary duties to the unit owners to act in good faith, in the best interest of the unit owners, and exercise due care and diligence in carrying out your duties for the community or for the betterment of the community. So you got to act above yourself or self-interest in dealing with the association and the unit owners directly.
Okay, I see that there's a shout out from Rob Ansel of the famous condominium firm of Perkins and Ansel. We're looking to change it to Ansel and Perkins, but that's been a fight over the decades. But his comment was go Jake.
Oh, and let's, I'm gonna make a on the fly amendment to the Celtics. If you can't make it to next Wednesday, we also have Celtics tickets for April 5th against the Toronto Raptors. Could be fighting for that first place seat at that point. So we'll leave that option open if you can't make it to the Wednesday event. Only if you can't make it though. Don't abuse it.
And Jake can push sports because he loves them and is very knowledgeable about them. And our governor, as of March 1st, is now the president of the NCAA for college sports. I like pushing education. So my comment on the fiduciary duty is unit owners think too often, that we represent all of them, and we don't. Your attorney represents the association acting through its board. It is not a true democracy where owners vote on every issue that comes up. And it certainly isn't something where 100 unit owners can call, for example, me and say, well, you're my attorney and this is what I think. That is not the case. So don't confuse fiduciary duty to the loyalty of duty to the association, implying anything about representing any particular unit owner.
Yep. And yeah, it's based on specifically how the statutes are worded as fiduciary duty, and the legal precedent is it's a special relationship between the board and the unit owners. And yeah, this usually involves kickbacks, abuses of power, things like that, where it seems like the board is acting for personal gain over the interests of the unit owners.
Okay. So, if I could do the management records very quickly, there are 3 ways of doing this. In the olden days, unit owner requested records under the statute in Massachusetts. They're open to inspection at the office where the records are kept. You can charge a reasonable cost for for copies, and there's some who believe that you can charge administrative fee as well. So you could have somebody come to your office, go through the box, tag what they want photocopied, and charge them. The other way that this could be done is that some of these documents, like maybe the condominium documents, could be on your portal. And then the third option, which a lot of managers like these days, is Condo Search and HomeWise put various documents, even including with buying and selling units, that can be purchased, and it's all done electronically. And it's a very speedy method for getting the records. There's a cost for it, but bottom line is, no matter what of the 3 ways or any others that you come up with, unit owners do have the right to records. But in Massachusetts, if it's condominium, it's very specific items. It's the condominium documents, minutes, financial statements, and contracts. It is not every record or every communication. On emails, I read a good article by Tom Moriarty of Moriarty, Troyer, and Malloy about email communications or text communications where court ordered they all be shown, and they had been destroyed. It's called spoliation, and there's a possibility of litigation. The court wasn't a condominium case, but the court ruled that you can't destroy text and emails. One suggestion that I think I've mentioned to others before is consider getting a domain name with the name of the condominium, or maybe the name of the management company, if you can break it into separate portals so that, or even a group chat so that all board communications with the manager and attorneys and all that is all in one place versus in your personal email or business email. The concern is God knows what might be in your personal email and business emails, but you probably don't want the world to know. And I heard this answer from somebody who uses DuckDuckGo, which keeps searches visit, is you don't want to put anything in emails that you that would shock and you'd get scolded by your grandmother if she saw them, or that would get you in trouble legally. So be careful with what you say through communications, and don't avoid meetings that are supposed to be if the meetings are supposed to be open, which in Florida is more the case. There was also a question by David Abel. I shouldn't have said the name. There was a question by somebody about town roads. Wow, Jake did the screen on it, and the you should have insurance for that. You can probably create a mini homeowner association, but talk to your own homeowners carrier and see if their coverage could be expanded to protect you if there's a lawsuit for, say, a slip and fall or damage to a vehicle because of potholes or a car accident because of allegations you didn't plow properly. But at least have insurance, consider a mini association. Jake, do you have anything?
Yeah, that is the end. Again, type in Celtics or an answer or a question in the chat. I just wanted to go back to the management records question. I dealt with an arbitration down here and basically ruled that the unit owner could get almost every email from the property manager and board's email accounts. Unfortunately, yeah, and as Steve mentioned, it's a good practice to come up with one domain to centralize all of the emails. For this example in the arbitration, they basically ruled that the property manager's personal email, the emails from that account were going to be able to be reviewed by public record request, which is not ideal because it included boxes and boxes of personal emails. It was printed out. So we had to go through and figure out what we were going to deem as privileged. And that was so just best practice, try to get a centralized domain for your community. Rather than
that may be difficult I don't know how managers can set up sub accounts under the management company name, but my concern would be I don't want to have managers who now have to set up 100 separate condominium domains. So if it can be done under the management company with sub private groups, or if it can be done just by however you would do like group chat, so all the communications are there. But the managers probably have some ideas in terms of how can this be done without it being overly unwieldy.
Oops, I just accidentally got out of the slideshow. But
looks like I've aged in the last hour.
So no, that was it ended up being not a Marcus hour, but a Marcus 70 minutes. So you got a little overtime and free extra 10 minutes from us. Again, thank you. Type Celtics, type in your questions. If we didn't get them to them today, which we got a lot of great questions, there's plenty in the chat that look awesome that we're gonna get to, dig into, and give you kind of specified answers on your issue. We'll get that in a document and send that out to all of you. Type in Celtics, type in any more questions you have, and if you type in Celtics or a question, you have an opportunity to win Celtics tickets for either next Wednesday, March 8th, or April 5th.
All right. They and I'll end with, we're about 10 days away from changing the clocks to get an extra hour of sunlight, which I think should be all 12 months. We're close to St. Patrick's Day. St. Patrick was a saint, I ain't. And spring is coming 4 days after that. And the Red Sox opener is going to be in April. So Jake doesn't feel bad that we all are going to get snow in Massachusetts and New Hampshire because he's in sunny Florida living the dream. Thanks, everybody. Sorry for, as usual, talking too much.
Thanks, everyone. Have a good weekend, and we will see you all next month, and we'll follow up with other answers that we didn't get to.
And come up with topics if you think there should be another type of format.
Yeah, we'll accept any feedback. You can let us how bad we were. That'd be awesome.
Well, the only feedback I got was a dear friend, again from California, who said that he really enjoyed the webinar, but Jake was the much better public speaker, and all I did was ums and whatever. So someday I want to be Jake, but who doesn't? Bye all. Have a great weekend.
Have a great weekend, all.